you're charged with driving while your license is suspended. You're facing up to 6 months in jail and or $2,000 fine.
The expired registration as of December 2023 and expired insurance as of November 2023. A traffic stop was initiated and the officer made contact with the driver, the defendant, and the defendant did not have a driver's license due to outstanding tickets. The defendant had 18 outstanding Class C misdemeanor warrants.
18 warrants?
What I have, Your Honor.
I'm assuming it's still, have you run it lately? Mine-
Not.
Mr. Espinoza, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to drive any vehicle whatsoever for any reason until you have a valid Texas driver license and liability insurance in your name. You will be signing an affidavit. This is a promise that you're going to make to me that you're going to drive. I don't care what's going on in your life. I don't care if there's a burning building and you need to save 50 kittens. If you get into a car and drive, every time you do it, it's an offense in and of itself, punishable by up to 6 months in jail and a $500 fine. Do you understand?
Yes, sir.
This is the affidavit you're going to sign. I don't care if you have to work. I don't care if there's a baby being born. I don't care if Jesus needs a ride to church. Do not drive. I'm going to have you come up here, swear to us that you're not going to drive. Do you have the ability to hire a lawyer, Mr. Espinoza? Do you have the ability to hire a lawyer?
I hired one.
Oh, Judge, Brian Levine signed out this morning.
Yeah.
Oh,
At the Sully attorney this week.
okay. I guess let's do this. I'm going to have you swear to us you're not going to drive. I'll get you to Victoria, sign a reset, and then we'll have you take a seat while we wait for your lawyer to get here. Do not leave until he gets here and we have you sign a reset and excuse you. All right? Come on.
Judge, counsel is a.
Mr. Sosa, you're charged with interference with the duties of a public servant. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir.
On April 9th, 2025, in Harris County, Texas, an officer was dispatched with a call for a suspicious person. The witness stated there was a Hispanic male at the back of the business causing a disturbance. The witness stated that the male was intoxicated and threatening an employee. The officer went to the back and noticed the male arguing with several people. The officer gave several verbal commands for the defendant to stop. The officer told the defendant to be going to be detained for safety. And the defendant continued to walk away and stated, it's always the Hispanic trying to get the Hispanic. The defendant refused all verbal orders given to him, and the officer detained the defendant and notified him by the Texas driver's license. The officer noticed that while detaining the defendant, the defendant continued to say, why for your brothers this stand.
What did he do? How did he interfere with anything? I didn't hear anything. Hispanic on Hispanic injustice or what?
Additionally, Judge, do we know that this was being told to him in Spanish? He's clearly not English.
You're losing?
Your Honor, the only thing I have is that the officer was continue to walk away from the
He's
officer.
walking while Hispanic or what? No, I'm going to find no probable cause. All right, sir. There are people, when they drink, they become very happy. They are the life of the party. And there are people who, when they consume alcohol, they become the devil incarnate. If this is you, it's probably not a good idea to drink. Now, I'm finding no probable cause in your case, but be careful. You know, we have enough violence in this place as it is. All right? Please, take a seat for me. You are Miss Murphy Smith.
Yes.
Ma'am, you're charged with theft. You're facing up to 6 months, 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am. Okay.
On September 29th, 2023, a law enforcement officer was dispatched to a residence and made contact with the complaining witness. The complaining witness stated that the defendant and her mother took items from her vehicle and would not return them. The complaining witness stated that she had been contacted by a friend informing her of the theft and that the defendant had stated she was going to spend all of the complaining witness's money and max out her credit cards. The complaining witness inspected her vehicle and found her belongings missing. The law enforcement officer spoke to the defendant over the phone. Excuse me, ma'am. And the defendant.
This is classic Judge Fleischer. Part judge, part life coach, part motivational speaker. He's not just ruling on a case, he's trying to rewrite a lifestyle. Moments like these are why his courtroom clips go viral. Law meets raw honesty. Do you agree with his tough love approach here?
Return them when given the opportunity to do so. The approximate value of the items taken was $600.
Okay. Ms. Murphy Smith, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to have any contact with the complaining witness, not to go where they live, and not to go near their car. These are your bond conditions. If you violate these conditions, a warrant for your arrest will be issued. You will go into custody. No more PR bonds. Do you understand, ma'am? Yes.
Yes, sir.
You have the ability to hire a lawyer, ma'am.
No.
We will have you fill out an application. I'll take a look to see whether you qualify. If you do, we'll provide your lawyer today. Deputy Miranda's going to give an application. I'm going to have you sign a reset with Victoria. We'll have you take a seat in the jury box and then don't leave until we release you, ma'am. Okay, please. Mr. Ramon, you are charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
On April 9th, 2025, in Harris County, Texas, an officer was dispatched to a theft at Target. The officer arrived and made contact with loss prevention employees who stated they observed two Hispanic females, later identified as the defendant and co-defendant. They were in the store selecting merchandise and placing items in a shopping cart, specifically concealing some of the items in a baby car seat while one was pushing the cart. While this defendant was adding merchandise to the shopping cart, she removed the price tags from selected items. Meanwhile, the co-defendant walked through the makeup department, selected 3 items, and placed them in the baby car seat, along with other items they had previously chosen. The co-defendant then proceeded to the jewelry department, where she selected a purse, and both females then moved towards the front of the store, approaching the cash registers without making any pay for the items in the car seat, and exited the store. Without attempting to pay for the merchandise in the shopping cart that the co-defendant was pushing. The defendants were positively identified from previous AFI smoke shop photos, and the total value of the items taken was $150.98.
Okay. It's Walmart?
Target, Your Honor.
Target. Mr. Ramon, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to go to any Target for any reason. Do you understand?
Yes, sir.
If I find that you do, I will revoke your bond, put you in jail. No more PR bonds for you. I am also ordering you as a condition of your bond not to have any contact, hang out with, or be with Ms. Monsivai. Do you understand?
Yes, sir.
If I find that you're hanging out with her, likewise, you will end up in custody. If you don't have anyone to pony up $5,000 to $10,000 to get you out of jail, you will be stuck like Chuck in there until this case is over with. And I'm telling you, it'll take 9 months just to get, certain types of evidence. Do you understand? What do you do with yourself these days?
I stay home, taking care of my mom.
Did you graduate from high school? What are you going to do with the rest of your life, ma'am? If you need something to do, this is not the right way. That conviction will kill you because people know, you need something to do. When people have too much time on their hands, they become self-destructive, ma'am. You need something to do, and now is the time for you to figure out what you're going to do with the rest of your life. You only have so much time. Before you know it, 5 years will pass. If you've done nothing, you're either going to, hanging out with the wrong crowd and be reliant on a man. You need to be strong as a woman. Never rely on a man. Knowledge is power. We're going to work on that. Do you mind appointing her a lawyer? So what we're going to do now is I'm going to have you go to Victoria, sign a reset. We'll have you take your seat in the jury box. I'm going to find you a lawyer here, and then we'll figure out how we're going to go forward. Don't become a danger to our community. Don't hang around with the wrong people. They're just going to bring you down. You understand, man? Okay, come on.
This way.
Over, and over. Now on our fourth. You now stand charged with prostitution.
On April 9th, 2025, in Harris County, Texas, an officer is conducting an undercover investigation and observed the defendant walking on the side of the street. The officer observed that the defendant was exposing part of her breast and made contact with the defendant. The defendant asked the officer if the officer was the police, to which the officer replied he was not. And the defendant gestured with her hands a 100, indicating values. The officer, whose training experience, recognized this to be a tactic used by prostitution workers to mitigate verbal conversations because they're aware of police reporting tactics. The officer then whispered 100, 104. The officer gestured a closed fist, entering and exiting the officer's mouth to indicate oral sex. The defendant then nodded her head up and down to indicate a yes response. The defendant then told the officer to get a room at a nearby hotel. The officer stated the defendant gestured a 2 and 5 to indicate the price of the hotel. The officer left the scene and gave the predetermined bus signal, and the defendant was detained. The officer stated the defendant was positively identified using her FBI.
Okay. I'm going to find that there's probable cause to go forward with your case, ma'am. Here's what we're going to do. I'm putting a monitor on your ankle now, and I'm forbidding you from going to any street from these cases that you've been on. If I find that you do, I'm going to revoke your bond, put you in jail, and I'm going to make your bond high. It stops today. Do you understand? The next thing that we're going to do, I will appoint your lawyer, but it's time for you to get a real job, a 9-to-5 job, one where you actually work, get up, go to work for 8 hours, and then go home. I'm going to bring you back in 2 weeks, and I want to see what you have done to fill out a gajillion applications. If nothing gets done, it's not going to go well. Do you understand? But this stops on our 4th, no more. And if I find that you're engaging in any type of way, do you understand? So I'd like to look at all the streets for every single case that we've had here, and then we're going to forbid her from going to any of these streets. I want it to ding and a GPS monitor so that we know she's not going to any of these streets. And we'll go from there. I'm going to have you sign a receipt with Victoria, and then I'm going to have you take a seat in the jury box while we work out all the details, man. Please.
Purpose of the monitor other than the exclusions, did you want a curfew or anything?
Yeah, I guess so. Right. Yeah. Let's do a curfew so she's not out in the middle of the night.
7?
No, I mean, I don't want it to be restrictive like 9 to 6. Yeah. I don't want her going anywhere near any of the streets on any of those prior cases. No drugs, no alcohol, and must get a full-time job. Mr. Finley, you're charged with evading arrest or detention and unlawful carrying of a weapon. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Judge, I'd like to start out by prefacing that the unlawful carry is based on the defendant being under 21 years of age.
Okay.
And then I'll proceed with the.
Yeah.
On April 10, 2025, in Harris County, Texas, a law enforcement officer was dispatched to a disturbance with a weapon call. The 911 caller gave a description of an individual with a gun at an intersection. And law enforcement officers, upon arrival, found a defendant who matched the description in the intersection. The defendant looked at the law enforcement officers, marked the car, and ran from the law enforcement officers. Law enforcement officers then said to the defendant, "Police, stop," and the defendant disregarded the command and kept running. The defendant then ran into an apartment complex and met a dead end, then stopped running and was detained. The defendant.
So they saw the gun on him. They saw him with a gun.
Your Honor, I don't know that they saw him. It's after he was detained, they found the gun in his front right pocket.
What led them to him in the first place?
There was a 911 call. It seems the 911 caller did see the gun.
Okay.
And then the officers were dispatched.
That's the description of this dude with the gun.
Yes, Your Honor.
So cops come, he takes off. Okay.
And then he was detained after evading for approximately 100 yards. And then the law enforcement officers searched the defendant and found a pistol in the defendant's front right jacket pocket, a small bag of marijuana in the defendant's front right hand.
Okay, here's the problem. You're on felony probation. So I'm gonna find that there's sufficient probable cause, Mr. Finley. Let's do this. Do you mind appointing him a lawyer today? And then we'll have him talk to a lawyer. For now, you are not to use alcohol or dope, be in possession of a weapon. You're on felony probation where you're looking at 2 to 10 in the penitentiary. You're supposed to live life as if you have a halo above your head, Mr. Finley, because if not, you're looking at up to 10 years prison. You understand? What do you do with yourself these days? Do you work? Go to school?
Before that, I said got arrested. I got fired.
What were you doing?
So
Okay. It's time to get back to the jobs. You need to get a job, and I am making that a condition of your bond as well. If I find that you're not working, just doing nothing all day, it's not going to go well for you. I'm going to test you like crazy. If I find that you're using, it's not going to go well. Do you understand? I'm giving you the opportunity now to not use, because I'm telling you, I will test you 45 days from today. And if you continue to use, it's not going to go well for you. Do you understand? So back again in 2 weeks to see about a job. And then, so for now, I'll have you go to Victoria, sign a reset. We'll have you take a seat in the jury box while we have you sign bond conditions. You will meet shortly here with pretrial for your bond conditions. All I want are my streets to be safe. You do anything to my streets. You understand me? Come on.
You want to just clarify?
I'm finding probable cause on both cases.
Both cases, yes, Your Honor. Thank you.
Yeah, he's on felony probation, you know?
Yes, Your Honor.
You mind bringing up Miss Gibbs? Yes.
Counsel for reset?
Joseph, who you got?
Judge, I've got Benny Hernandez.
How you feeling?
Yeah, I'm not too great, but I'm managing. Judge, we can, this case, we could possibly do a plea on it today if we can do it all through the portal, if I can sign the documents through the
Yeah,
portal.
I'm sure we can.
Okay.
Do you know what offer you're gonna take?
The state's offered 15 months of probation.
Okay.
This is second
Yeah,
DWI.
everything can be done through the portal. Do you have your guy's phone number so you can, talk to him
Yes.
outside?
Yes, I do. I believe he's in the courtroom right now.
Benny Hernandez, your lawyer's gonna call you now. Step outside, talk to him about everything, and then when you come back in, we'll get it done. Okay, so Ms. Gibbs, the reason I'm bringing you out now is that your lawyer is asking for me to give you a PR bond on your failure to identify oneself. I don't know, I have to look at what's going on in your life to see, should we give you a PR bond? Are you a danger to the community? I
Not
mean,
at all, sir. Not at all. I'm a college graduate. I've got 4 kids I need to take care of. I have a job. I have a vehicle. I have no problem getting to court at all. Like the last 2 court dates that I had with my felony, I had a miscarriage and I was in the hospital. And they're aware of that.
everybody tells me it's little bunnies jumping in the woods.
That's
You know?
the only thing it was. It was, I had a for real miscarriage.
I get it, but you're on bond for a felony endangering a child.
Mhm.
You've picked up 2 fraudulent uses. And now, after those 3 cases, you've now picked up a 4th case of failure to identify oneself. So
They were all in this.
Stop.
Okay.
You have the right to remain silent. I just want to know what's going on
Yes, sir.
to see whether we should give you a PR bond, because this is not a revolving door,
I understand that.
Yeah.
I apologize.
So we're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. Okay, please.
Thank you. On April 2nd, 2025, the officer was monitoring a neighborhood police radio broadcast. The officer heard a broadcast call for the theft of a department store off of East Sam Houston Parkway in Harris County, Texas. The caller gave a description of the defendant and explained the defendant had just left the store. The officer arrived in the area and found the defendant as she was described by the caller, along with a male individual with the defendant. The officer observed the defendant and the individual enter into a motor vehicle and exit the parking lot. The officer observed the motor vehicle had no front license plate and expired registration. The officer conducted a traffic stop and made contact with the defendant. And the defendant identified themselves as Kathleen O'Brien, date of birth, May 24th, 1982. defendant stated she did not have any ID card on her person. The officer looked up the defendant by the name of date of birth on the public safety photo, and they did not resemble the defendant. The officer asked for the name and date of birth of the defendant once again, and the defendant gave the same name and date of birth. Due to the photograph not matching, the officer attempted to confirm the defendant's name and date of birth with the mobile FIS. That would turn the actual identity of the defendant as Candace Lynn Gibbs, date of birth July 16, 1981. Along with a Harris County Sheriff's Office mugshot of the defendant that matched the driver of the vehicle.
So they didn't charge her with a theft?
I don't believe so, Your Honor. Or they did not.
So what's going on with the 2 fraud cases that she has that shows like no bond?
Not sure.
You know anything about those cases, Lori?
No, sir. I know that she went to court on the 15th, 14th,
15th, yes,
on
ma'am.
the 15th on the. I received an email from her felony attorney stating that this was the only case that was holding her in and to see if I could move her up to get her out.
She said something that they weren't filed or they weren't, or something hadn't been done where.
Yeah, the she said they weren't filed yet.
They're filed. I guess the judge just hasn't signed it yet.
Your Honor, it looks like there was a plea offer made originally for the endangerment of a child. And that plea offer has been made now on the fraudulent use case. That was just, I believe, discussed between the felony prosecutor and the defense attorney.
In this case, Lori, in the fraudulent use case, in her clutch, as they pull them over, she has the identifying credit cards, debit cards of 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25 different items of other people's identifying information. You are on bond for endangering a child. You pick up 2 fraudulent use cases and now allegedly at a store doing whatever with a failure to ID. I'm not going to sit here and give you yet another PR bond. You know, at some point we have to say when, and now is that time. Your bond, literally $50 to get you out, right? But I can't sit here and continue to just perpetuate this thing over and over and over. All I want is my community to be safe, you know?
I understand that,
So
sir.
I'm going to find probable
In an
cause.
abusive relationship.
Don't say anything, but got to understand that, right, I'm not going to give her a PR bond, Lori. I'm sorry. All right. So, ma'am, what we'll do now, your felony cases are set for the 30th of April. We can set you for the day after and we'll go from there. Okay. Thank you, ma'am.
That's what we said.
Okay, so Mr. Sherrill, you're charged with terroristic threat. You're facing up to a year in jail and or a $4,000 fine. We have already done probable cause. I found probable cause to go forward with your case. We set a bond. He's made the bond or no?
Yes, he has.
You've made the bond.
Yes.
Okay. So I am entering in what's called a magistrate's order for emergency protection. This is a court order that identifies Ms. Taylor as a protected individual. You cannot commit family violence or an assault against this person, commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where she lives or where she works. Do you understand? They're not currently together now?
No.
Okay, great. So there's just no,
So,
I don't want to talk about the case.
no, it's not. She still like communicates with like my family and my friends. Like I don't even live here, and it's events come like my best friend's wedding.
I'm going to the wedding, but she's trying to come. So how do I have
Got to be careful, you know, you're not to have any contact with her, you know,
Sounds like she's using, I don't know if she knows there's a restraining or a protection
She
order.
is using, the officer was a personal friend, so that's why.
Okay, well,
so this merely says that you can't go to or near her residence, right, where she lives, where she works. Don't have any contact with her. The problem is that there's a lot of vindictive people in this life. You know, if you go to the same place that she is and you end up bumping into each other and she says something to you, you know, it's a recipe for disaster. So you have to be very careful. If you go to this wedding and she's there, it's like a ticking time bomb. So you need to be just very careful because I don't know, you know, what kind of person she is. If she's that type of person, you got to be very careful because there are a lot of people that will call them and say, hey, this happened, when it's just not true. And if it does, they issue the warrant and then it's up to you now. You pick up another charge. So just be careful, you know? All I want is just you not to have any contact with her. Don't be in possession of weapons. As long as you can do that, we're cool. I'm going to waive your appearance so you don't have to waste your time coming to court here as well. Just stay in touch with counsel and he'll tell you if and when you have to come back to court here. So you don't have to come back and forth every single court date. Just stay in contact and he'll let you know if and when you have to come back.
I appreciate it.
Do you have any questions?
I guess so.
You live in Baltimore, right? Okay. So for now, what I'm gonna have to do is I'll have you sign a reset with Victoria. We'll have you take a seat in the juror box. We'll get your bond conditions, I'll have you sign it, and after that, you're free to go. Okay? Hi, Anna.
Good morning, Judge. Hi, privilege.
Yeah.
I've got a couple to talk to you about this morning.
You do the easy ones first?
Well, whenever I have to talk to you, Judge, they're never easy.
That's not true.
Fair enough, fair. But these,
I know. Okay.
the first one is going to be Wilson Keonje. Start with the less difficult.
Okay.
Can we hear PC on this one?
Is it, you say Keontae? Keonjae?
Keontae.
Okay, yeah, of course.
On February 6, 2025, a law enforcement officer was dispatched to an assault at Provision High School. Law enforcement officer arrived and observed 15 to 20 students fighting each other and struggling with staff members and security guards. The law enforcement officer retained a number of students. After seeing mostly calmed down, the female was struggling and fighting against male students to run out onto the floor and rejoin the fight. The law enforcement officer approached the males and told the female students' hands behind her back. The law enforcement officer got closer. The defendant turned towards the law enforcement officer, put his arms up to stop the law enforcement officer's progress towards the female and said, no, no, no. The law enforcement officer grabbed the defendant's shirt and told him not to interfere, he would be taken to jail. The defendant replied, I will, and remained in the law enforcement officer's path. The law enforcement officer handcuffed the defendant and ordered him to get on the ground and began pushing the defendant towards the ground and told him to get on the ground again. The defendant remained on his knees, pushing out against being pushed. The law enforcement officer pushed the defendant down towards the wall. The defendant pushed up, causing the law enforcement officer to fall to the ground. The defendant righted herself before continuing to struggle with the defendant to get him to the ground. I believe that's a typo. The law enforcement officer righted themselves.
So there's a fight.
Yes, Your Honor.
The officer is asking him to move, get out of the way, so he can do whatever he needs to get done, and he just refuses to get out of the way.
Yes, Your Honor.
Anna?
So it sounds like the interference is my client doing this.
He's impeding the path of where he's trying to go or what he's trying to do.
Okay.
Right? I mean,
That's what I have, Your Honor.
is there a body cam on this?
It looks like we do have a significant amount of video.
You seen the body cam? Does it show that?
I have not watched them all because it's quite a bit, Judge.
Okay.
But
You remember, it's a low burn.
I understand.
Probable cause, and he's, you know, the officer says, hey, move, man, I gotta get this stuff done. And he's like, no, I'm not gonna move, I'm gonna stay here, just, you know. I mean, I get it's just standing there, but,
Okay.
so look at the video. If you see something different, let me know.
Okay. The next one I have to talk to you about is Torrance.
Come up, Ms. Torrance.
I've spoken with the state. And so there's kind of a couple of things going on. I'm assuming you want to do the BVR first. I've spoken with the state. We are going to ask for a hearing. I'll let the state speak for themselves because
Your Honor, We do not have any toxicology bag. We have blood alcohol report, but that is not the toxicology report.
Well,
Or
talking about the bond violation
bond
report.
violation, I apologize.
It's okay.
I apologize.
I don't think the state is prepared to have the hearing today. But
I've got bond violations. The Scram device has confirmed alcohol consumption violations on 3/15/25 at 1:51 PM, 3/23 at 7:14. Confirmation was received 3/25/25 by the analyst, and it's a third bond violation.
I understand, Judge, but those,
Let her go.
the rules of evidence apply at a bond hearing, and we need somebody with personal knowledge or somehow to get around that hearsay to do the hearing, and I don't think the state's prepared to do that today.
We do not have anyone here to do that today, Your Honor. I apologize.
Hey, who do we need? What Scram analyst do we need to get down here? So we can, right, so they can testify that what's in the BVR. I'm sending her now for a drug and alcohol test right now as well.
I'm going to send her for the test now.
Right now.
Okay. Okay. Have a seat, and then once they put the order in, we'll have you go over there. Okay.
She can have over reported during.
Okay. Okay. Go over to 41 San Jacinto. Okay.
And then Anthony, do you see, who do we have that can come?
Yeah, I'm gonna
You
get
might-
a name and.
Yeah, okay,
We'll
get it. I'm gonna try to get it today. Okay, who else?
And then, well, so the secondary issue, on Ms. Torrance is we have gotten the alcohol report back. They sent the, blood off to get analyzed for toxicology.
Oh, Lord, did you just send the blood off?
Oh, and Judge, if,
No,
Verify when that,
this case is 233 days old and we have violation after violation. I'm not waiting anymore. She's way too much drama for me and I'm ready to set this thing for trial. I'm not doing it anymore.
For the courts, I did email the person on that side, just got a response. Toxicology analysis still in process, pending completion, it's likely requires some time before the lab board received.
Did you just send it?
No.
Wait.
We've been sending follow-ups, this was like a last Hail Mary attempt of, do we have it or do we not? They still have it.
Do you have other things to go on regardless?
I think we have.
No?
Spoken with defense counsel, there is, I mean, proper, there was alcohol in the system.
Well, look, it doesn't matter to me, however you guys want to do it, but to me, way too much drama. I'm setting this case for trial. That's it, you know, because
yeah, and he has laid an offer, I just,
I need to talk to her about the offer. If it's not moving anywhere,
Okay.
I'm setting it today.
Okay,
Way
and-
too much drama.
just to remind the court, when I was here last time, you gave them 30 days and said if they didn't have the report, that it wasn't coming.
Okay.
I understand the state has to do its job.
Okay, so can you take a look and then, you know, take a look
Absolutely.
and then let's go. But yeah, I'm ready. Hi, Maverick.
Hey there, Judge.
How are you, man?
Doing good, you?
Sorry to bring you down here.
No, it's good.
Is your client here?
He is.
Should we bring him
Come
up?
up.
I did speak to pretrial and they did confirm that they are kind of in the mistake. We didn't not comply. This is because we did come here to court on a Monday 4/7. And when you were here, you already knew his results
Last meeting.
of Bennett.
Okay.
And so you already knew his results and you told him, look, I already know your results. There's no use to test him on Thursday. Because he was on a Monday, Thursday at the time. Let's switch him to once a week. We can't tell him when he would be tested next week, but you know, which day, but sometime next week he'll be tested. So on Thursday, they of course call him and he's like, okay, I already was told not to do it. And then he did not go. And so it put him in the system as a BVR. When he was, in his opinion, following directions.
Okay, I'm gonna send him now, I
That's
guess.
fine. And they even said.
As long as you're
today.
clean, I'm happy. I just don't want anything in your system, especially oxy. You know, that's all I want. I'm not asking for much, you know? We'll send him for a test now. Hopefully he's clean. If so, everybody's happy. I won't ding him on this. You know, if he's dirty, I don't know what we're gonna do. So let's do this, because it's gonna take a while and I know how busy you are. Leave me your cell phone.
I'm trying for 3 all day today.
But I can text you, so that way you don't, don't say it.
Okay.
I'm here. If you write down your cell phone, please, and then I'll text you. All right, just take a seat for me. We're gonna send you here momentarily, Mr. Ben. Hi. Hi.
Lacey Johnson, Mental Health Division Judge. How are you?
Great to see you. What's new?
Just trying to do some more work in misdemeanor. And if you haven't heard, we are supposed to be having full-time misdemeanor mental health prosecutors coming online in the next couple months. So we're very excited about that.
That's exciting.
But in the meantime, we're trying to,
Guys that you have now are great. They're just so understanding and great.
yeah, well, I think there's a lot of things we can do to help in misdemeanor court. And so that's what I'm here to hopefully do today. On Mr. I beg your pardon if I'm butchering his name, El Majzoub.
Yeah,
Okay,
that's correct.
he is on docket today. I can give you a case number if you
Is he
need
in
it.
in
Yes,
custody?
he's in custody.
Are you handling just mental health? No.
Yes, I'm handling just mental health.
Is that recent?
Lori and I are just handling mental health.
But is that recent or no?
No, since I've been here, I've just been in with mental health.
Okay, what was the cause number?
So his first cause number is 255-6958.
And that's the document that I filed. It was the agreed stipulation of evidence. That's what we filed.
And so I got a notice that she had filed for a motion for competency exam. I took a look at the cases. This gentleman has been through competency restoration services before and has a well-documented mental health history. And so I told her, rather than waiting for an exam, which I feel fairly confident I know the outcome of, I will agree to stipulate that he is incompetent so that we can go ahead and get the services started. So what we're asking you to do today is to sign the stipulation of evidence, sign your regular order that you would for competency restoration services.
Yeah.
And then if you could also enter the order for clinical assessment for outpatient or jail-based competency restoration. So if we can see if either of those options would be appropriate for him.
Huh?
Yes.
Yeah,
Thank you,
great.
Judge.
Yeah, just, if you mind putting it in the queue, it's on El Mazouk. Page 32? Yeah, 31 and 32. Yeah. So everything's been already filed, right? So he just put it in the queue?
So
9 minutes?
the two orders are ones that should be in your order database, but I'm happy to confirm that those are the right ones once they've been pulled up for you.
No, I don't,
It's
We
usually,
can take a,
yeah.
I don't usually file it.
No, it's usually should come from the clerks have it in their database.
yeah, that's one of the documents that needs to be signed.
So the order for competency restoration, and I can give you the statute if you need it. And then I can show you the other one, but it's called Order for Clinical Assessment for Outpatient or Jail-Based Competency Restoration.
That one. We'll get it. We'll get it, but it might take a
And
little
I can
second.
show it.
Let's show them.
Okay, as soon as I get it, we'll sign it.
Wonderful. Thank you, Judge. And
Do
then
me a favor though, do you mind maybe like email all three? Hi, come on.
And there it is, the curveball. The judge isn't just questioning the charge, he's questioning whether the communication itself was even understandable to the defendant. Remember, if a suspect can't comprehend an officer's commands because of a language barrier, it weakens the state's case significantly. What do you think? Was this interference or just miscommunication?
Hi, good morning.
Here on Javier Marin this morning.
Okay.
And I spoke with the chief. There was a mistake about it being a DWI second. In fact, the DWI first that they thought was the issue was actually reduced to a reckless driving charge. And so this is actually just a true DWI first.
Yes, and so we would check, like,
And the chief has made a time served offer today that I believe
Wait a second. Can you run his NCSC, please? Because usually it's a DWI and they might reduce it to an obstruction or a reckless, but it's a DWI. Right? And the thing is that the last thing I want is for him to wrap his car around a pole because he continues to get proverbial slaps on the wrist, you know?
and then at this point, that's all you need to. Okay. If, so when you send these stuff together for the outpatient or jail-based programs, they'll send us back a report and if,
Sure.
he's admitted to either of those programs.
So we did submit a PTI litigation packet for him as well, just under the assumption that.
I mean, that's up to you guys. The problem is it's 190 days old, right? That's should have been like a long time ago, right?
Yes, it's really.
Let me know if you need to come back. Otherwise, maybe want to check in and.
They filed it as a second, and I'll tell you, let me look at the information.
Sorry, give me 1 second.
Yeah, it looks like he was convicted of a DWI in Lawton, Comanche County, Oklahoma in '01.
Laura?
Yes, Your Honor, it was. It was a DUI. Okay. Sorry, I'm trying to decide.
Take your time, there's no rush.
And like I said, it looks like it that way, right, I was driving, but the DUI was dismissed. That's.
It was reduced and wasn't dismissed.
It says dismissed, I think, there's no language on the NCIC.
So it said dismissed and then at the same time,
that
a reckless?
Says, dismissed in 2001, guilty, and then a guilty plea for a traffic offense. Then we heard the municipal prosecutor, and then in June, so in. I'm not sure, it might have just been dismissed. Was it, where do you have that?
It's from the attorney of record. He said that he was speaking with Abigail Balance. From my understanding, the previous introduced a reckless driving equivalent from Oklahoma, and then she wrote back.
I'm sorry, the NCIC just doesn't clear exactly how that transaction.
Yeah, it's not an US second, it truly is not, it was, we got
It's
to.
reduced from it was,
I don't really have to know the law. But it is not that DWI. That is.
was it a DWI that got reduced or reckless or an obstruction?
All right, there you go. You're free to go.
Oh, Jane, that's higher. So I misspoke, Your Honor. We did not get a JNS back because there is no JNS from Oklahoma. Only thing I can see was there was a DUI charge, no information on it. It's hard for me to track, but there are no DWI convictions. So it's hard for me to track to see if that charge that we have that was, we don't need the JNS on, was the one that was.
They usually don't file it, just.
Right, because it was in Class C.
Or well, that's a mall, so it's different. That would be the equivalent of Class C here.
What do you want? One time serve?
We would like to give that offer to our client today because
I mean, we got to do something today. It's 190 days old.
it's today, but
Oh, it's waived.
could have it coming on the next setting.
Yeah, so what we'll do is we'll set you off a week. Okay, have your client come in so we can take care of it. You know, I'm okay with just, can you go ahead and do the reduction now? How do we,
So, yes, Your Honor, so what I can do is I could, because we're reducing it, I can complete paperwork, Your Honor, we are changing,
well, we'll need the new NCIC regardless, right?
I'm sorry.
We'll need the new NCIC regardless.
Oh, yeah.
Do you know the NCIC by heart? On
In
the
Your Honor,
first?
the offer you've made, it's within the consent. It's
Okay.
within the class.
Is it above a 0.15 or no? Okay, so yeah, if you want it, I'm okay with it.
Judge, and also we did apply for PTI. I don't know if that's still on the table.
Do you know, have you turned it in?
And as of yesterday, yes.
Oh, as of yesterday.
As of yesterday, Judge.
Do you see that it's been turned in?
So we submitted it to,
So regardless, I mean, do you want the PTI? Is that what you want?
my client would really like that. He would.
So go that avenue and we'll see if they are, down. Have you filed mitigation paperwork explaining to them that it's not a second though?
Yes, Judge.
Okay, great. Because they need to know, because they're gonna automatically refuse you if they think it's a second.
That was my whole look before I made this. But once I saw it, and I can tell you, Your Honor, the date is for passing on.
Okay. I just want to confirm that you have the image.
I don't know that.
It was sent to Lindsay Tizard.
Oh, no. That's, okay.
And Flo Dufocon.
So let me.
You guys get together. I'll give you a week to 2 weeks to get the response and we'll go from there.
2 weeks.
Yeah.
Thank you, Judge. I appreciate it.
2 weeks. They're filing the PTI today.
Okay.
Mr. Hernandez, you're charged with driving while intoxicated, second offense. You're facing up to a year in jail and or a $4,000 fine. You have worked out an agreement where they're offering you 1 year in jail. This is to be probated for 15 months. As part of this agreement, you will do a DWI repeat offender education class. You will do 2 victim impact panels. You will do a TRAS. This is an evaluation to see what other conditions you need. If they assess other conditions, you must fulfill them, including substance abuse treatment. No drugs, alcohol, no breath test refusal. If you are pulled over while on this probation and an officer asks you to submit a breath test, you must do it while you're on this probation. 40 hours of community service. Do you have any children, sir? Do you have any children? $100 one-time donation to the Houston Food Bank. Three days in Harris County Jail as a condition to begin May 9th. You are way, way too young to have 2 DWIs going on your record now. This is a damn shame. And the reason is because you will probably be driving for the next 50 years. The problem is that are you going to remember this in 20 years? Are you going to remember this in 30 years? Look at me. What happens if you pick up another DWI? No. No. Prison. You're looking at 2 to 10 in the penitentiary if you ever pick up another DWI. And you don't have to be sloppy, falling down drunk for you to get another one. Just the mere smell in and of itself. When they look at you and they look at your record, they're going to make assumptions. If it walks like a duck, talks like a duck, somehow I have to get a hold of your attention so that you understand that we mean business, that it's unacceptable for this to continue to happen. I'm now going to hit you with a surcharge of $4,500 that you will be required to pay. And if you don't pay it, every $100 that you owe, you will sit 1 day in jail. Do you understand? We will give you a sufficient amount of time to pay, but if you start clowning, you pick up another case, you consume alcohol. If you pick up another DWI, I will issue a warrant for your arrest. We will have a hearing, and you're looking at an entire year in jail. Do you understand? I hope that you don't pick up a felony, but the problem is that time heals wounds. In 30 years, you will have forgotten about this, but the law never forgets. So you go out on a date, you win the lottery, whatever. You understand?
So,
You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You also give up the right to appeal. Once you accept this agreement, you are stuck with this until you're done, you complete it, or if it gets revoked. You understand?
yes, sir.
This is what you want to do.
Yes, sir.
How do you plead to the offense? Guilty or not guilty?
Guilty.
I'm gonna find you guilty. So the total fine that he will owe is the $4,500, and how much your court costs?
The 4,500 plus the 410. So
So-
4,910.
You will owe now $4,910. We will give you at least 2 years to pay. If you need more time to pay, we can give it to you. If you have any problems while you're on this probation, you can come back and talk to us. She's an extraordinary person, always willing to help. It's not about, I mean, the worst possible thing you can do is just take off. Issues come back, we can always work through anything. I am now required to suspend your license. I'm going to suspend it for 1 year. Do not drive. You understand? You get popped driving, it's not going to go well for you. You understand? Okay, man. Good luck.
Your Honor, one additional,
Yes.
I'm sorry, Judge. One additional thing.
Talk to me.
Mr. Hernandez has had a breathalyzer in his vehicle for the past 7 months. He's been in compliance the whole time. Does he have to keep that in the vehicle?
So I'm suspending his license, Joseph. I'm suspending it for a year. So what we'll do is we'll take it off now, once he gets his portable device. He's got to get the portable device first.
All right.
Okay? You need to understand that every officer in this state knows that you're not allowed to drive unless you have an ignition interlock in your car. You get pulled over and you don't have an interlock in your car, they will arrest you and put you in jail. And then we file a motion to revoke. So don't attempt to drive. Find another way around. Do you understand? I know it's a hardship, but somehow, Mr. Hernandez, we got to get a hold of your attention. Look at the news. Every day someone dies in our county. Hopefully this is the last of it. Good luck. Waive all his fees as far as supervision. Yeah. Okay. All right. Good luck, Mr. Hernandez. Hi.
Thank you, Judge.
Thanks, Joseph.
You're welcome.
Take care, man.
You too.
Okay. Hi.
Well, this
Okay.
one's Butler.
So what'd you find?
Yes, I spoke to his sister, Dorisha, and she confirmed that she can pick him up once he's released and that he can stay with her for as long as he needs. And keep an eye on him to make sure he stays out of trouble.
Yeah.
18 warrants. Yes, you heard that right. At this point, the judge isn't reviewing a case, he's reviewing an entire trilogy. Quick legal note. Each Class C warrant may be minor on its own, but stack them together and you're basically speed running your way into courtroom trouble. Comment below. How many warrants do you think someone has before they stop pretending it's a mistake?
We know where he is. Okay. Do you mind bringing Mr. Butler out? Yes.
I did request if she can come this morning, but she had to take her kids to school. So she.
So, but it takes time to get out anyways. So it takes, can we do release instructions to a particular person?
Can I do?
How do we do that?
So if they're in jail and we're trying to release them to a certain facility or person,
No, to a person.
we can do that.
We can do, say it again.
Either the state or defense will have to file.
So there's a motion that you can file that he gets released to that person.
Okay.
I don't know how we get it though. I don't know. how
I
we
have a
get it.
copy of one.
So that way we can put her
But it
name
was
on
for
it.
a facility, so I need to check.
That's okay. I mean, we can somehow,
We accept those formats, just you'll have to edit it to address the certain.
put her name on it so we know. Because I'm not gonna hope that they actually, but this way we know that he's actually released to this person. And we got to monitor so we know where he is all the time.
Oh my God. Yes, please. That would be great.
You are so very lucky that she's worked so diligently to find a place for you to go to. Who is it that is willing to take him in? It's sister?
The sister, Dorisha.
Your sister is willing to take you. I don't want you out on the street. This is the only chance that I'm going to give you to do what is right. Go to your sister's house, stay there, and try to find a job if you can. You have to remember, you're in her house, so you have to follow her rules. If she gets upset, if she asks you to do something, be nice, do it. Because if you make her upset, do you think she's going to want to keep you there? If she kicks you out, I'm going to keep you. I don't want you roaming the streets. Do you understand?
Yes, sir.
I will have a monitor on your ankle so I know where you are at all times. And I'm also, so curfew as well, so he's not out in the middle of the night. We are filing an order so that she is the only one that can pick you up and take you back to the house. So you have a place to go to. This is the only chance that you have to do what's right, Mr. Butler. Can you get it done?
Yes, sir.
I'm not going to play games. So if you just take off and start roaming the streets and take off, a warrant issues, and I'm not going to do this again. No more PR bonds for you. Do you understand?
Yes, sir.
Are you sure?
Yes, sir.
Can you do this?
Sir.
Okay, great.
Thank
All right,
you.
Stacey.
I'll file it this morning as soon as I'm done.
Sure, thanks.
Thank you. And I'll be back for Mr. Ramos,
Let him know that his curfew of 9 p.m. to 6 a.m.
9 p.m. to 6
And
a.m.
then he's got to stay at the house. Do you think he can work? Do you think he can work?
Oh, it can work?
Do you think he can work?
So I'm gonna tell them about the microphone and then officer social worker.
Oh, wonderful.
And
Yes,
like.
that's a great
give them a
idea.
list. I think I got it from your report, Your Honor.
Great. No, that's a wonderful idea. Let's have him talk to the social workers so we can figure out what's going on in his life to try to get him a job or even an ID if he doesn't have one. Yeah, wonderful. Great.
And Your Honor, if I may, I did a little bit of research on the school that he's attending. And it's to help students who are low risk of not graduating. He has been enrolled since October 2024. I do have a copy of his courses if you would like to take a look.
I guess, yeah. You know, my main concern is him, number one, not going to prison. Number two, messing with the wrong person and they shoot him dead. Every other week, you hear of people going after a car. They mess with the wrong person. That person has a gun and they shoot him in the back. It happens all the time. And my fear is that he goes out and picks up a 1, 2, 3, 4, 5, 6, 7th case. My feeling is that home confinement is the only way that we can protect the community and at the same time prevent him from picking up any more cases. He's got 5 open felonies and they're serious, serious cases.
Muy serious.
Nada?
Do you work? No, do you work?
Yes.
What is your work schedule?
Es horario de trabajo. No, pues yo pido permiso por
¿Qué es su horario de trabajo?
dentro a las 10,
I go in at 10
a las 6 de la tarde.
and I get off at 6 p.m.
So you work every day?
¿Vas todos los días?
No, descanso un día.
I rest one day.
So who's going to take him to school?
¿Quién lo va a llevar a la escuela?
Pues yo ya hablé con el señor del trabajo.
I already spoken to the man at my job.
Ajá.
So you're not taking him to school?
Sí,
Usted
yo
no
lo,
lo hace.
yo lo llevo, yo ya
I
hablé
take
con
him.
él.
I take him, I already spoke to him.
Ya después me voy para el
And
trabajo.
then I'll go to work.
I don't know if I believe that. I mean, I don't. You're telling me you work every day.
Sí, pero yo, como le vuelvo a decir, yo ya hablé, yo no-
Like I tell you again, I've already spoken. ¿Con quién habló?
con el patrón de mi
My
trabajo.
boss at my job.
I would only let him go to school if I know that you're taking him. I don't want other people to take him. I don't trust other people to do the right thing. So if I find that other people are taking him, I'm going to put him in jail. I want to make sure that if he's going to school, he's actually going to school and going nowhere else. I'm putting a GPS monitor on him, and we're marking the streets that he needs to take to go to school. So if he's not on that exact street and he deviates from it, the GPS will ding, and I'm going to bring him back to court, and we will have a hearing as to whether I'm going to revoke his bond. His bond is set at 10,004 now. If it gets revoked, it's going to go extremely high with his 5 open felonies, and now he's on probation for our case. You were telling me that you're going to take him.
Yes.
What hours did you want?
Él entra a las 7. Lo más tarde que él tiene que estar en la escuela es a las 8.
The latest he can go in is at 8 a.m.
Y lo más tarde que él llega a la casa a las 1:20. Por 1:20.
Okay. And he gets at home like at 1:20, so classes from like 8 a.m. to 1 p.m.
How many days a week?
Él va de lunes a viernes.
I thought you told me it was a 4-hour window that he needed to go to school. Right? The felony says 4 hours.
It's like 1:35 p.m. to 7:25 a.m. Something like that. Would be when he needs to be back in the house. Like he cannot go anywhere prior to 7:25 a.m. and he needs to be home by 1:35 p.m. That's why that allows him to attend walk into classes.
Saturdays and Sundays, you must stay home. Not to go out. I have a monitor, so I know where you are at all times. You ever test positive for anything illegal, your bond. Do you understand me? The only thing that you're allowed to do is go to school, and that's it. I don't want you to go to HEB. I don't want you to go to JCPenney. I don't want you to go to GameStop. Do you understand me? Nowhere else. You deviate one iota, it will not go well. We need to know the exact street that you're taking to get to school and get back. You understand? Okay. All right, Stacey, that's it. Okay.
That's all I have for today.
Thanks.
Have a great weekend. Happy holidays.
No puedes pagar también la tienda. Cuando lo reportes a la escuela, tiene que ir directamente para la casa, no la tienda, no. Porque se sale.
Ah, Mr. Sandwick. Not happy with you. You know, you're on bond for a theft, right?
Yes, sir.
I would put conditions on him. Literally, what is it? The next day you pick up another theft? I don't know. Let's do probable cause in the case. You have the right to remain silent. Anything you say can and will be used against you. Please.
Thank you, Judge. On April 14, 2025, in Harris County, Texas, a law enforcement officer was dispatched to a Walmart for a theft call and made contact with a complaining witness, a loss prevention officer, who stated he observed the defendant conceal merchandise in a shopping bag and pass all points of sale without paying. The defendant was detained and the merchandise was valued at $265.27.
Okay. Mr. Sandwick, so I'm going to find that there's sufficient probable cause to go forward on your new case. Because you picked up a case while you're on bond, all we did, we asked you to behave yourself. Don't pick up any new cases. I'm now going to revoke your bond on your first case. So on the first case, it's now at 5,002. And then I guess we'll just set you for whatever you want to see what we're going to do.
Yes, sir. So
Tell me.
So now that all that's being said, the state and I have entered into an agreement for Mr. Sandwick to plead guilty to both of these theft cases, Judge, in a plea agreement.
Oh, I mean, if that's what you want to do, I'm I have no problem with it.
Yes, sir.
You have to understand, if you get out of here right now and you pick up a third theft case, what happens?
You won't see me again.
If I had one strand of hair, every time someone told me, man, I would have.
Me too. I swear to you, you have my word.
I don't care, your word. Right here. That's where your word means.
Your Honor,
I'm just telling you, what happens if you pick up another one?
I won't.
A third is a felony offense and you're looking at years instead of days. Forewarned is fair warned. I'm happy to do whatever you want to do. If you want to, you absolutely have my blessing. The only problem is you pick up another one, it's a felony offense.
Okay.
You understand?
Yes, sir, I do, Your Honor.
Yeah, whatever you want to do. I'm happy
Yes,
to do
sir.
it. Okay.
So we've signed the plea paperwork,
you read it?
Judge.
Oh,
yes, that's where-
God, I had no idea.
So there's
Okay. Oops.
12 for 4 and 6 for 2.
Okay, so I didn't realize that we were doing this. Sorry.
No, Judge, I wanted to first bring him in front because he did need to be arraigned, Judge, and then I wanted to bring that matter to you, Judge.
So, Mr. Sandwick, like you have worked out a fast agreement now. You understand that probably not all the evidence is in. You have the opportunity to go through the evidence. Perhaps someone's wrong.
I'm sorry.
Is this what you want to do?
Yes, sir. Yes, Your
You
Honor.
need to understand that by pleading guilty to both of these theft cases, they will go on your record. They're going to be there for the rest of your life. They're even there after you die. So if you want, run right back to Walmart and then you pick up a pack of gum and put it in your trousers, what happens?
Third step, sir.
Do you know how many cameras they have in Walmart?
I do not.
Do you know that they have facial recognition software so that every time your happy butt walks in there, it's going to directly ping on your face so they know it's you?
Yes, Your Honor.
You're giving up the right to a trial, right to compel witnesses to test on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you plead guilty to these offenses that will go on your record, they'll be there for the rest of your life.
Yes, Your Honor.
This is what you want to do.
Yes, Your Honor.
Do you want to plead guilty, not knowing that not all the evidence is in, that it, something could come in that it, gets you off?
Yes, Your Honor.
Okay. How do you plead to both theft cases? Guilty or not guilty?
Guilty, Your Honor.
On both of the theft cases, you're facing up to 6 months in jail and or a $2,000 fine. On your first case, it's 6 days in jail with credit for
It's 12 for 4 and 6 for 2.
2 days credit. On your other case, it's 12 days in jail with credit for the 4 days that you've done. You sure you want to do this?
Yes, sir.
All right, sir.
Yes, Your Honor.
I'm going to find you guilty. I will follow the agreement. Good luck to you, sir.
Thank you.
Thank you,
Thank you,
Counsel.
Judge.
It's all right.
Yeah.
Do we have DVD?
So, well, I talked to Gabe. He doesn't want to come down here. He says he's just going to defer to whatever you say. Yes.
You don't care?
I'm sorry?
You don't care?
Judge, the complaining witness, a screenshot of the YouTube, put him on blast and sent it to him 5 times on Saturday night. So he doesn't want anything to do with this case.
Oh.
And as I mentioned, these are the 2 charges. One was actually out on bonds for aggravated assault with deadly weapon for stabbing her boyfriend. She also had a prior assault slapping her mom, so she's not an angel. And like I said, my client does have an 11-month-old baby that he co-parents with. He also takes care of his mother. This is a statement from the doctor that he has Alzheimer's, so he takes care of his mother that has Alzheimer's.
My concern though is that, did it happen? Did he take advantage of her when she was in a semi-conscious state, There, is it? I mean, I just,
And like I said, Judge, none of this was in the forensic interview. It was like an hour long. She never mentioned any of that stuff that she was mentioning to you.
Why would we reward him further?
I'm sorry?
Why would we reward him further?
I don't think it's a reward, Judge. I think it's justice. I mean, case is what, almost 3 years old now? He came to all his trial settings. I mean, he's lost jobs opportunities because of this. He has a bachelor in telecommunications.
Confinement in a house, that's not punishment. You know, I'd sit there and play Fortnite all day. That's like a dream for me, quite frankly.
Right,
I mean, what kind of punishment is that to sit there, you know?
I mean, it's loss of income. He's the sole provider.
I don't know that. I mean, it's just, how do I know that? You could be taking time off, you could take vacation for 10 days, you know?
Stand up.
You know, but it's not really a punishment to just stay at home and get to just hang out.
Plus, we also need to look at it. Granted, it was up there, but it's in front of you as a Class A indecent assault. So, you know, would that merit, if it wasn't a felony, it was just charged as an indecent assault, would it merit 10 days of jail as a condition of a 2-year deferred? We don't even do that for DWIs.
If you want more time, I'm happy to give you more time, you know? I don't know, Joe. I don't know. I don't really. I don't know what is appropriate, what is not. If you need more time, you know,
I'll defer to the court, Judge. Like I said, I'm just advocating for my client.
I know, and I'll give you more time so he doesn't have to turn himself in tomorrow. But, you know, just sitting at home, that's not punishment. They filed a case. If he really was not guilty, then you go, right? You try the case. And I don't understand why, you know, just
And we were gonna go, that's why we were set for over a year, 7 times, ready to go, ready to go. And then now at the last minute, the state comes back and says, Class A deferred dismissal, no registration, sexual registration. Bingo, who's not gonna take that, Judge?
right.
When you just heard
If
of,
you want more time, I'll give you more time. I don't know if I'm ready to just, there has to be some, you know, yeah, I don't know. I mean, if you want more time, I'm happy to give you more time for him to turn himself in, you know. I don't think staying at home is a punishment. It's not. And I think that we have to balance the interests of everyone involved, you know, really. Your main concern is the job, right? Is that your main concern?
right, and then, like I said, he helps with the baby and then takes care of his mom as well.
Okay, I'm sure he can find someone else to help take care. So look, what I'll do for you is find out whatever he has vacation, and I'm willing to give him some time, you know, so that he doesn't lose his job. Because I don't want him to lose his job as well.
You do weekends?
I don't think, they don't do weekends, do they? They don't allow weekends. They don't have the manpower to do it. When you do it, it has to be straight time.
Okay.
Yeah. I'm willing to give you more time if you want to talk to him and see what's better for his schedule so that we don't, because I don't want him to lose his job, obviously.
Okay.
And you know, I'll go down to like a week, 7, but there has to be some kind of punishment, really. And because I just don't think that home confinement, that's not punishment. That's a gift. For me, that'd be a gift. I can play Fortnite 24 hours a day, man.
All right, Judge.
Yeah.
Okay, Judge, I'll call him right now. Okay, thank you.
And they gave you another PR bond. This is not gonna happen again. I don't care, come hell, how you miss again, I'm gonna make your bond so high. Do you understand me?
Sir.
We're not asking much. The only thing that we're asking you to do is bring your happy butt to court. That's and obviously stay out of trouble. All you have to do is come to court. And the next time you fail, do you understand me?
Yes, sir.
You are not allowed to drive. There is an affidavit The other worst thing you can do in this short life that we have is get into a car and drive without a license and insurance and approval from us. Because if you do, then you're facing a contempt hearing. Do you understand me? We've so much as even given you a lawyer. It is your responsibility to stay in touch with Mr. Reed. If he tells me he can't get a hold of you. Okay, so we'll give you a reset. Is there an offer on this case so far? I know it's young, but
There's,
Gonzalez.
There's not, Your Honor.
I'll get with him, Judge. I'll take it.
I know.
All right, thank you, Judge.
All right, guys. All right. Good morning, Mr. Thompson.
Sir.
Sir, you are charged with the offense of resisting arrest.
It's 18 for 6.
Um, So you've got two cases with us. You've got the resisting arrest. You also have a fugitive case where you're wanted out of
Mississippi, Your Honor.
Mississippi. So what's happening now is you're pleading guilty to the resisting arrest. I don't know if you're on probation, if you're on parole or whatnot, but you need to understand by being on probation or parole, you pleading guilty to this offense can result in further incarceration, having your parole revoked, whatever it may be. Do you understand?
Sir.
You give up a lot of rights by entering into this agreement today. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this agreement, you can never change this or turn around, and you understand.
Sir.
The agreement is 18 days in jail, credit for the 6 days that you've done. By this going on your record, you need to understand here in Texas, you are now facing a minimum of 90 days in jail. As far as the other case, it is a felon in possession of a firearm. Has he waived extradition?
Yes, Your Honor.
Okay, by you waiving extradition and by you now taking care of this,
Oh, he has an account.
the demanding jurisdiction, Mississippi has 14 days from today to come get you. If they don't come get you, Harris County will release you. But you need to understand that that warrant, if Harris County releases you because they just don't come get you, that warrant will always remain in effect and will always be there until you go back to Mississippi and take care of it. You understand?
Sir.
How do you plead to the offense? Guilty or not guilty? I'm going to find you guilty. I'm going to follow the agreement. Good luck to you, sir. Thank you.
Thank you, Your Honor.
And with that,
This is one of those situations, Judge, where he doesn't have state ID in the system, so he hasn't been apist. So.
how has he not been APIS? He's been in jail. I mean, as soon as they get him, they fingerprint and mugshot them, don't they? Every time.
They don't have a state ID number in this friend in this case.
I get it. So they'll probably create it, right?
Hope so.
You tell me they didn't, when they booked them in, they didn't fingerprint and mugshot?
Well, usually we'll get the ID number, we'll.
So as soon as they get that number, then they should like,
Yeah, so it's gonna be weird.
regardless, he's here for another 14 days.
Okay.